So I have an update for you in the California magazine ban case Duncan v. Bonte, which is currently seeking Supreme Court review. So let's talk about this. But real quick before we jump into this video, if you think bans on magazines is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, I have an update for you in the California magazine ban case Duncan v. Bonte. Duncan v. Bonte is a case challenging the state of California's ban on magazines that hold more than 10 rounds. This case was already extremely important because it would impact California residents, but with the new Washington state magazine ban, it has become even more important since Washington is also in the Ninth Circuit's jurisdiction. For those of you not aware of Duncan v. Bonte, previously known as Duncan v. Becerra, this case involves the possession of so-called large-capacity magazines in California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds by ordinary citizens within the state. This law was challenged in the Southern District of California, and District Court Judge Roger T. Benitez, or St. Benitez, issued a ruling that found that this law was a violation of the Second Amendment. This led to what is called the Freedom Week in the state of California, and during this single week period of time, millions of magazines were purchased, brought into the state of California, and essentially are now possessed by California gun owners. The state of California obviously did not like the St. Benitez ruling, so they appealed that decision up to the Ninth Circuit. This also resulted in a stay having to be issued on Benitez's ruling, but during the kind of appeal process, those individuals who purchased magazines during Freedom Week have been able to maintain possession of those magazines they purchased. A 3-judge panel in the Ninth Circuit reviewed this decision by Judge Benitez and agreed with his ruling. Well, even after that, after losing at the appeals court level, at the 3-judge panel level, the state of California decided to seek a rehearing en banc, which means a review by 11 judges in the Ninth Circuit. The en banc panel heard the case and issued their ruling, finding that California's magazine ban does not violate the Second Amendment. The en banc panel found that this ban in the state of California was not unconstitutional, although it did implicate Second Amendment issues, i.e. the possession of magazines, because individuals were still able to possess some sort of magazine, being a 10-round magazine, to defend themselves. So they had some sort of option available to them for self-defense, and that's all the Ninth Circuit cared about. The en banc panel therefore reversed the decision of Judge Benitez. This decision by the en banc panel now led to the plaintiffs in Duncan filing a petition for Supreme Court review, because that is kind of the next logical step, because along the way they got a favorable ruling from the district court judge, the 3-judge panel, and the only unfavorable decision they got was the en banc panel, and the only way to override that decision is at the Supreme Court level. In this petition to the Supreme Court, the plaintiffs hit on 3 major issues. First, the petition seeks to have the Supreme Court address whether an outright magazine ban, which also has a retroactive confiscation component in it, whether or not that is a violation of the Second Amendment. Second, whether a ban that requires people to turn over magazines to law enforcement, destroy them, or to permanently alter them is a governmental taking. And finally, the plaintiffs seek the Supreme Court to review the Ninth Circuit's incorrect 2-step analysis approach, which they frequently use to uphold these types of Second Amendment violations. Another important thing that the plaintiffs pointed out in their petition to the Supreme Court is that 50 times out of 50, the Ninth Circuit en banc panel has upheld restrictions on the right to keep and bear arms. In these cases, the Ninth Circuit always states that the item in question is protected by the Second Amendment, but then goes on to say, well, under their 2-step approach, the item can still be banned or restricted by the government. Even worse, on this specific issue, not only did the Ninth Circuit say that California could ban magazines, but they also said a retroactive confiscation ban on magazines is okay, despite the fact that the state originally wrote the law so that the possession of these grandfathered magazines was in fact lawful. This is why this case is so important for the state of Washington, because Washington is really a clone of California, and that law that they just passed is kind of a California clone, but they're just like 5 or 10 years behind the state of California. The new Washington law says that grandfathered magazines and their possession is lawful right now, similar to how California originally was. But it will only take time for the state of Washington to all of a sudden say that they need to close that so-called loophole, and they need to change the law to also ban retroactively those grandfathered magazines. So after the plaintiffs filed the petition to the Supreme Court, we were waiting for the state of California and the Attorney General's office to file their response, which would be due on April 1st. However, the state of California filed a motion for an extension of time, which appears to have went unopposed. In the motion, the state of California states, "Dear Mr. Harris, the petition for a writ of certiorari in this case was filed on February 28th of 2022, and the response to the petition is currently due on April 1st of 2022. Pursuant to Rule 30.4, Respondent, the Attorney General of California, respectfully requests that the time for filing a response be extended by 31 days up to and including Monday, May 2nd, 2022. An extension of time would allow for adequate time for internal review and would better enable preparation of a response that respondents believe would be most helpful to the court. Respondent has also received several requests to consent to the filing of amicus briefs in support of the petition, and the extension would allow time to review those briefs and prepare any response to the arguments made in them. We have been informed that counsel for petitioners does not oppose this request." Subsequent to that motion, the Supreme Court actually did grant that motion, so the state of California will not need to respond to this petition to the Supreme Court until May 2nd. This further kicks this case down the road, but there are some positives that kind of come with this being delayed a little bit longer. The further the briefings get pushed, the more likelihood there is that the Supreme Court will actually issue their New York State Rifle and Pistol Association v. Bruin decision before this petition gets too far along with the process. One of the biggest question marks really on both sides of this Second Amendment case and other Second Amendment cases as well is how in fact the Supreme Court will handle a lot of these cases going forward. A lot of those question marks will in fact be answered by the New York State Rifle and Pistol Association decision, which should come at least by the end of June. Actually, something I want to mention that was kind of interesting when I first saw it the other day was that from oral argument to published opinions, the DC v. Heller case took about 100 days and the McDonald case took about 120 days. Currently, the New York State Rifle and Pistol Association case had oral arguments on November 3rd of last year, so currently we're 145 days out since those oral arguments. So we are well beyond the average time in comparison to those other two big Second Amendment cases. So New York State Rifle and Pistol Association could be coming sooner rather than later. The Supreme Court is currently going to drop some more opinions this Thursday morning, so I will definitely have my fingers crossed for maybe a Bruin decision before we ever expected it. But regardless, we know that they will have to issue their decision at least by June. Another good thing that comes out of these extensions is that it can create more time for third parties to write amicus briefs in support of getting rid of these types of magazine bans. Amicus briefs are very important and can add into arguments that sometimes the Supreme Court takes into account when they look at these cases. And I would fully expect to also see a bunch of amicus briefs come out of the state of Washington, various organizations in the state of Washington, because again, they just instituted a new law and a new magazine ban there. So they definitely have an interest and they will be filing likely amicus briefs on various levels. So that is where the Duncan v. Bonta California magazine ban case stands as of right now. It is up for Supreme Court consideration and the deadlines have been pushed a little bit further out. Californians and likely Washington residents right now really have their eyes fixed on the Supreme Court. And of course, if we get any more information on this that will impact the state of California or Washington or really any of these Second Amendment cases, I will definitely let you know. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. If you don't have a comment in mind, just comment down below that your comment will fuel the algorithm, and that really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget to stay with Built Bar Scholars and stay maintain Bar Scholars.